And I believe the answer is going to be, in my heart, a sort of settlement proposal. And that's what I believe is going to try to occur, because these de facto courts and their agents and agencies are going to want to save face. So they're going to ask, what kind of a settlement will we accept?
But I thought you just got through saying that they're going to end up in jail, and that's what I was talking about. Well, who's going to enforce them going to jail?
If the judgment rendered consists of a jail sentence, who will enforce it?
Yeah.
It should be the adversary court.
Within the de facto paradigm.
That's right. Because remember, if they don't, what do they get? They get the charge. And I'll tell you, there's no butt on the chair in that black robe that wants any of those charges to come against them.
Yeah, you're right. Yeah, that makes sense.
So they don't give a damn what they're going to do. They're going to save their skin.
Mm-hmm.
And if that means taking down an attorney firm and a mortgage company, they're going to do it.
Right, yeah. Yeah, I think you're absolutely correct on that. Wow, we got them fighting among themselves, potentially.
Yeah. So, again, for every communication you get from anybody, it begets a negative averment counterclaim with charges from you against them. And if you invoke the international jurisdiction and the authority of the UPU, Universal Postal Union, which we've talked about on several shows here, and the power of that group, now we really have something that I believe these de facto agents and agencies are going to come to regret and fear.
Okay. All right, go back to one thing. Did you say the way to contend with, say, a summons or a charge is through a negative averment?
If you have whatever you're being charged with, set up your research and your history to know what you can come back and charge with. And the biggest thing that people need to learn is challenge procedure.
Mm-hmm.
Show me the charges. We had a person in Oregon that was facing 25 years and 15 years and $250,000 fine. He went into that scenario and challenged the procedure, requesting the court to bring forth the charges. And when the paperwork was properly set up and put in, that individual ended up receiving a 30-day sentence and $270 fine.
Now, what do you mean by bring forth the charges?
The charges is their claim, not just a written thing on the statutes, but you have to prove what the charge is. And none of the de facto prosecuting attorneys want to identify the charge because there is no charge.
And there's no charge because they didn't enact the law properly. Am I correct in that?
Correct. So again, prove the charges and prove the act underwriting your claim as to that act's constitutionality.
Now, by proving the charges, do you mean proving the authority that they have to even bring charges?
It's all in there, such as when you get an IRS thing in the mail and they want to charge you with some part of the IRC code. Okay, prove to me the act underwriting your IRC code, underwriting your claim against me. Now, was this document you sent me registered on the Federal Registry? Does it contain a proper OMB number? And was that OMB number properly passed and registered on the Federal Registry? 9 out of 9 3/4 times, they're never registered. They never carry an OMB number. They have no authority for any of it. Fine, you sent me this document, I'm sending you a negative averment, and I'm going to charge you with being a pirate engaged in a piratical enterprise because you failed to prove the constitutionality of the act underwriting your claim. And you failed to prove the proper registration on the Federal Registry with a proper OMB number on your correspondence. Have a nice day. I'll either throw you into a bankruptcy adversary hearing or I'll throw you into straight federal court hearing. Take your pick. Doesn't matter. You still have to prove on the record. When you know what to ask for and you've done your studying, like I taught over a year ago on mortgages, on the registration requirements with the SEC, how to go into the Edgar archives, how to go in and pull out and find those S1 registration statements, the SQ3 or S3 registration statements, the 424B5 prospectus statements, and then to go in and find out where is the title page. Well, at closing, you didn't show me the title page. You didn't give me a copy of the title page. So title company, here you go, title director. You're now being included in a claim of piracy. Prove the title page. Prove the call schedule. Prove that the property was not paid for before I walked out of that door that day. Now they got a real big problem, don't they?
Well, aren't they going to maintain that they paid for it? And then that's why you owe them the money?
Bring forth call schedules.
And what exactly is the call schedule?
Page. The title page is like a court docket, Harvey. Court docket identifies all actions taken in the case, right?
Hmm.
Okay? So a title page does the same thing in terms of mortgages. It shows what was brought in, what was tendered, what was done, what the result was. So that's why when we had the banking individual on the line here about 5-6 months ago, he was a retired banking person that decided to come out of the woodwork and teach people when we were all asking for the note, that we were asking for the wrong thing.
Mm-hmm. Right. Yeah.
That we needed to be asking for the title page because the title page shows a balance of 0. Paid for. Paid in full.
Now, they don't have that title page at your closing. They've got it in their back office, normally.
Wherever they've got it, they still have to bring it forward if you ask for it.
Okay.
They still have the call schedules. They're mandated to file those, too.
And what's the call schedule?
It's just a schedule that they have to file. I think it's with the SEC. But I have not seen a call schedule yet. I've just studied the banking from banking individuals and say, yeah, these are the important things that people are not asking for. Okay, if it's important and I should be asking for it, I'm going to ask for it.
Can you make a list of those items and give them to Harvey?
Well, it's 3 or 4. The S1,
no, S1
S3, 424B5, prospectus.
Hold on a minute. S1, S2?
S3.
S3, I'm sorry.
I learned it in the beginning to SQ3, but it's listed as an S3. So you see any kind of an Edgar archives, when you look up the documents and you look up the type of document it is, it'll say S1, S2, S3, S6, whatever. You want to key in on the S1 and the S3. The 424B5 prospectus is also on that schedule.